Okay, good morning and welcome to Oral Arguments of Fifth District Court of Appeal. We are, excuse me, here on the case of State versus O'Neill Rondano. I'm sure I'm mispronouncing that
Arredondo.
incorrectly, but each have 20 minutes for oral argument. And these oral arguments are being live streamed and recorded so the public can view them. I'm Judge Evander. I'll be presiding over this morning's session, and I'm joined on the panel by Judge Edwards and Judge Harris. Each have 20 minutes for oral argument. Obviously, appellant is entitled to divide that time for rebuttal argument. Mr. Pallas, if you want to let me know how much time you wish to reserve for rebuttal, I'll try to help you in that regard, but there is a clock on your screen. The other thing is we have been having some feedback issues as far as our oral arguments this morning. So particularly ask Mr. Pallas, Mr. Hyman, when you're not arguing, if you go ahead and mute yourself. Okay, with that, Mr. Pallas, you may proceed.
Thank you, Your Honor. May it please the court, my name is Richard Pallas. I represent the state. The standard 5 minutes is sufficient for rebuttal.
All right, thank you.
It's our position that the trial court incorrectly granted this motion to suppress. The trial court found that because there was no mutual aid agreement, the breath test results had to be suppressed. And the state has 2 points for reversal, one of which is that this was a continuing investigation that began within law enforcement's jurisdiction instead of the investigation of a different crime. And our second point, more of an alternative point, would be that even if this could be considered a violation, it's not generative of the exclusionary rule. And this court should instead follow some of the well-reasoned out-of-state decisions the state cited in its briefs. I'll address the first issue primarily. And it's that under the color of office doctrine, of course, using the powers of your office when you're outside of your jurisdiction will warrant suppression. But there are exceptions to this, 2 of which are not applicable, being the mutual aid agreement exception, which we do not have any competent substantial evidence in the record, and of which the hot pursuit, of which the officer Perez testified he was not in. So here we're looking at the continuing investigation that began within his jurisdiction. Officer Perez went to a traffic accident that occurred in Winter Park. He read Miranda, and during his investigation, he performed field sobriety or administered field sobriety exercises to the defendant. Upon that, he found probable cause to arrest her for driving under the influence. And at that point, he transported her outside of the Winter Park city lines and into or the city of Orlando for the Orange County Sheriff's Station DUI center. And it's here we believe that this all is just a logical application of where this investigation began. Had, of course, this all began in Orlando, on the other side, such as in Matos, one of the most recent cases applying the exclusionary rule to the administration of Florida's implied consent law. In that case, it was a Pembroke Pines officer on the Miramar side of the highway instead of the Pembroke side. And in that particular case, everything of the investigation occurred there. The observations, the asking to take a breath test, and then, of course, this defendant was transported within his jurisdiction. But doing all of that, that was correct to be suppressed under the color of office doctrine. But here, again, Officer Perez was a Winter Park officer, and he was in the right in order to transport this defendant to here.
Counsel, what limitations are there on the circumstances you're talking about? And I realize there's a long line of cases that say if a municipal officer begins an investigation of a crime that occurred or believed to occur in his or her jurisdiction, he or she may continue the investigation outside his or her territorial jurisdiction. What limitations are there on continuing that investigation? I mean, is that something that has to be limited by time, by territory, by some emergency circumstances, or can it just keep going?
No, Your Honor, I don't believe it's something that can keep going unless under the proper circumstances it would warrant that. I believe that tracing back to as far as I can find of Florida case law applying color of office doctrine, the Collins versus State case, which is cited in the various authorities that we have. In that case, it clearly went on too long. The investigation began within the jurisdiction, but 2 days later, they tracked down their suspect outside of their jurisdiction in the adjoining city to question him. And of course, asserted their powers of office, saying, we are police with this particular jurisdiction, answer our questions. I understand 2 days is maybe a little too extreme here, but I think what's important is good faith. If, of course, in our case, just what occurred within minutes or hours, that should be fine because police have an interest to preserve the blood alcohol content or at least accurate results. If, let's say, the circumstances showed that the Orange County DUI Center was perhaps defunct, a hurricane had come through, then perhaps situations like that would dictate it. It might be a totality of the circumstances situation, but in the state's view, at the very least here, it's a proper line that this was within the county, just a city away, this would be sufficient. And of course, in some of the state cited cases, such as Hagen out of Rhode Island and also Pearson out of North Carolina, in these cases, they're taken over to adjacent cities. Something's wrong with their particular breathalyzer machines. And so they're told you should go over there. I don't believe in either of these cases we have mention of the mutual agreement or whether the mutual agreement was orchestrated. And I believe in those cases, it's very instructive to this court in order to say this is not the kind of violation of the color of office doctrine. And again, while Matos is obviously a 2014 decision, it's one of the most recent we have and the one that deals with breath alcohol levels. I think it's obviously important that this continuing the investigation instruction was still brought up in cases such as Knight out of the 1st District, which I believe was from around 2014 as well, and Nunn out of the 4th District in 2013 or 2011. I apologize, Your Honors. It's now, while those involved searching by a computer or recording calls, I believe that those where this investigation is happening now, and we only realize after in good faith that we weren't inside our jurisdiction, those were sufficient. Granted, Knight did have a mutual aid agreement, so it was not determinative of the continuing investigation exception. If Your Honors have no other questions, I'll reserve the rest of my time for rebuttal, but I ask that you reverse the trial court's order.
I just have one quick question for you. Is it significant in any way that there was not another law enforcement officer in Orange County to administer the breath test that was done by a technician or something?
I don't believe for these purposes it's significant, no, Your Honor, specifically because I know I believe out of the same district that decided Matos, the 4th District, forgive me for paraphrasing this case, Stouffer, that case was determinative of a different statute, not the implied consent one, but involving whether or not someone who is not a law enforcement officer could administer the breath test results. Again, because the state's position is that the lack of a mutual aid agreement or knowledge by the investigating officer thereof is not determinative of this, I do not believe that the presence of an Orange County deputy there at all affects this case, Your Honor. But if there are no other questions, I'll reserve the rest of my time for rebuttal, and I ask that you reverse.
All right, thank you. All right, Mr. Hyman.
Your honors, may it please the court. Our position is that the lower court followed binding precedent in the state of Florida when it made its ruling. It basically based its ruling on a trilogy of cases that started with State versus Phoenix, worked its way through State versus Sills, and then finally ended up with the Matos case, which actually dealt with a breath test situation. To me, the crux of the issue in this case is the color of office doctrine. And taking that in conjunction.
Mr. Hyman, and none of the three cases that you decided was the defendant arrested in the officer's actual jurisdiction, right?
Correct.
Does that make a difference if the arrest here occurred in Winter Park?
We don't believe it does, because I don't disagree with, there's a principle out there, if an investigation starts within the jurisdiction, the officer can go out of his jurisdiction and continue an investigation. The problem becomes when he goes out of his jurisdiction and then he uses the color of office to ferret out evidence that's not otherwise observable. And that's where the rubber meets the pavement, I believe, in this case. I'm not disputing that an officer can't go out of his jurisdiction and continue an investigation. But if you go back to the Griffiths case from this court, the Fifth District Court of Appeal case, that was a case where an officer from one county or one city went to another city to execute a search warrant after a search warrant had been authorized. And this court found that the officer did not have authority, because he wasn't a law enforcement officer, to conduct that search warrant, even though there was actually another officer present from that jurisdiction at the time. And so our belief is that, and we believe the lower court was correct, and it was actually bound by the Matos case, because the Matos case is the first case that at least I've become aware of in the state of Florida, and only case in the state of Florida, that has found that the request for a breath test is the use of color of office. And in this particular case, the officer arrested my client in Winter Park, placed her in handcuffs, transported her to the breath testing center, which is located outside the city of Winter Park.
In Matos, the court said that the color of law began when the officer began the DUI investigation in another jurisdiction. That's not our case. This investigation began in Winter Park. In fact, it was concluded in Winter Park to a large degree because she was arrested. In Matos, the DUI investigation did not even commence until the officer was in the outside of his jurisdiction. Doesn't that make a difference?
No, I believe when you have a search outside the jurisdiction, which the breath test would be a search, and you use an implied consent warning to compel the breath test, then at that point in time, you're using color of office. For instance, in the Sills case, that case started outside. It worked over into another jurisdiction, but the search took place in the other jurisdiction. In the Griffiths case, it took place in the other jurisdiction. Again, there is this line of cases that say you can go out, but even in the Sills case, they recognize those cases being argued here today, that there's a continuing investigation. And in the Sills case, they said that's fine, even if it originates within the officer's jurisdiction, he still cannot use the color of his office outside the jurisdiction to
That's
ferret
not
out
exactly, I think you're kind of glossing over a point. There were two crimes being investigated in State versus Sills.
Yeah.
One was a traffic offense. And if the officer had continued investigating only the traffic offense in the outside the jurisdiction, it would have been a different case, because the court in Sills does say that line of cases does hold municipal officers may conduct a lawful investigation outside their territorial jurisdiction if the subject matter of the investigation originated in their own. That's what we have here in Sills. The defendant said, hey, I got a bunch of oxycodone up in my house in a separate city, and I want to be a snitch for the police department. Two different crimes. two different events. Here we have the same crime, which you agree began in Winter Park, was investigated in Winter Park. She was arrested in Winter Park. So that's the continuing investigation and gathering of evidence for that particular crime by taking her to Orange County for the blood alcohol. I mean, Knight versus State recognizes that same line of cases. Phoenix is an arrest case. It's not a ongoing investigation that began of a crime committed in Martin County. They saw a guy in Martin County in a pickup truck with extra gas cans, and to them, kind of putting two together, they thought it looked suspicious. Of course, it's not a crime to have gas cans in your pickup truck. The crime in Phoenix was committed in St. Lucie County and was not a crime that originated in Martin County. Therefore, the Martin County Sheriff deputies were acting outside their jurisdiction. That's not what we have here. I mean, this case seems to me to fit squarely within the ongoing investigation of the same crime that began within the jurisdiction. And
Well, the only thing I can say in response to that, the language in Sills was that even if it could be said that in this case, the subject matter of the investigation did originate within the officer's jurisdiction, the line of cases relied upon by the state is expressly noticed in State versus Phoenix with the following caveat. Nonetheless, the principle espoused in these cases is subject to the proviso set forth in the text of our opinion that officers who act outside their jurisdiction, but not in fresh pursuit, may investigate and gather evidence only through the use of their own senses and through the voluntary cooperation of citizens. They may not employ the power or color of their office, either expressly or by implication, in order to gather evidence or ferret out criminal activity not otherwise observable. So,
but again, Phoenix was an arrest case. Phoenix was all about arrest.
But it did speak about using color of office to ferret out evidence, which is what this officer would be doing by requiring a breath test with implied consent warning. He's ferreting out evidence outside of his jurisdiction.
Let me ask you this, Mr. Hyman, a hypothetical. Let's say that your client had a big bump on her head, and after the arrest, the officer took her to the nearest hospital, which was in Orlando. And because there was an accident, he asked for a blood draw. Can he not do that?
Well, it would be questionable, Judge, because the situation here is that there's ways to do this, but they just weren't employed in this case. You could use a mutual aid agreement. You could use, assuming it was drafted properly, you could use another officer from that jurisdiction coming and taking over an investigation. There's ways to do it. But in this case here, there's no evidence of a mutual aid agreement. There's just an officer as a routine basis, it seems like, taking an individual to another jurisdiction and using the color of his office, because even the Sills case said by putting that in Mr. Sills in handcuffs and transporting him, that was color of office. And you add on to that in this case, the fact that the officer read an implied consent warning, which by its very terms, its express terms, says that only a law enforcement officer can request a breath test. And so we have express language in the statute that specifically limits it to a law enforcement officer requesting a breath test. The Griffiths case said that once an officer goes out of their jurisdiction, municipal officer, they're nothing more than a private citizen. So therefore, you have a private citizen using the color of office in order to ferret out evidence located outside of his jurisdiction. The
Let me
other
ask you
thing,
this, Mr. Hyman. If a municipal officer is transporting a prisoner who's been arrested for a crime in the city to the county jail, as soon as the officer leaves the city limits, is he no longer, acting as a law enforcement officer?
well, the cases go a lot of different directions in that kind of situation, but in that situation, he's not using the color of his office to ferret out evidence.
Right, but he's got a prisoner there. He can, You know, if
My
the prisoner
memory,
tries to escape, can it be charged with escape, for instance?
Yeah, I'm going by it's getting bad now, my memory, but I believe there might be some cases that say that when you're transporting a prisoner, that's okay. But there's not actually a violation of rights involved in that. You know, the Sobrino case, which we cited in the brief, there was a part that I did not quote from that, but if you look a little further down from that same paragraph, it says, our rejection of the state's claim is not due to a lack of appreciation of the difficulty and importance of effective law enforcement, but rather to our firm commitment to the view of those who wrote the Bill of Rights. So even in the Sobrino case, they acknowledge that, you know, it may not be convenient for law enforcement to do it a certain way, but the rights of the individual stand above the convenience factor. And basically, we have precedent going a long time back on the color of office doctrine. It's just more recently in Matos been clarified to apply to requesting a breath test. And I do recognize that Matos started with the officer out of their jurisdiction, but I don't think that's really where that case got decided on the breath test issue. I think it got decided on the breath test issue that the officer was out of his jurisdiction at the time he used the color of his office to request that breath test, and that requesting the breath test was the use of the color of office.
Well, quoting from your brief there at page 9, you say that subject to certain limitations, a municipal police officer also has no power to act as a police officer outside the territorial limits of his municipality. However, isn't that continuing investigation one of those lawful exceptions that's recognized in State versus Silas and Knight versus State and State versus Price?
And that may explain Judge Evander's situation where the officer is taking the person to the jail and crossing the state lines. That may be allowed. The problem becomes when you start using color of office. And that's where I think the distinction is, in that even that quote that we were just referring to came out of the Griffiths case from this court. That's specifically where it originated. And at the time that decision was written, it cited the Phoenix case for that proposition. And the Griffiths case, even though it involved a search warrant, it still involved a search that took place outside of the jurisdiction of the officer. And it involved a statute that allowed only a law enforcement officer to conduct the search. Just like here, we have an implied consent law that only allows a law enforcement officer to request the breath test. And so the similarity between the two would seem to suggest that, and especially if we follow the Griffiths case, that the officer, where there's a statute that specifically requires a law enforcement officer to do something, can't go out of his jurisdiction as a private citizen and do that using the color of his office. So we believe the Griffiths case also supports the argument here. While it's not a breath test case, it does deal with a search where there was a search warrant under the search warrant statutes, requiring a law enforcement officer with authority to conduct that search. I don't know. The only other thing I would like to bring up, I'd like to bring up these out-of-state cases that the state has been relying upon. Obviously, they're not binding on this court. However, when you actually read those cases, I don't see any mention of an under color of law office doctrine in those cases. And there is a lot of legal wrangling that goes on within the opinion in the Hagan case. And they recognize that there's one case that held one way and some other cases that held another way, but it was more like a public policy kind of decision that they made there, that they were going to, that it was okay just because it was a continuing investigation. But I believe in Florida, under our case law, it's been pretty well respected that the under color of office doctrine still exists. And the Sobrino case, which was also a jurisdiction case that we cited in there, that talks about the powers wielded by officers are vast and subject to abuse, Accordingly, such power has been restricted by strict construction, limited exceptions, and harsh remedies for the violation of police powers. Because abuses of police powers diminish our individual and collective rights, the penalty for any violation is one of the most serious, suppression. And that came out of the District Court of Appeal case in the Sobrino case. So we don't believe that these are like, this is a technicality. It actually goes to the heart of a law enforcement's officer's authority to do his tasks, but it also goes to the rights of individuals under our statutes. So specifically in this particular case, because he used the color of his office to obtain the breath test results by reading the implied consent warrant, transferring under arrest, that this case falls within the Matos case, that the request for a breath test was color of office and suppression was the appropriate remedy. And I believe that's what the lower court was following, absent some other evidence presented by the state, which was not presented, of possibly a mutual aid agreement. And if there's no other questions, then that would conclude my argument.
Any other questions? All right, thank you. All right, Mr. Palace, rebuttal.
Thank you, Your Honor. The state has just 3 points for rebuttal. First of which I'd like to address, Judge Evander, your hypothetical about transporting to the county jail. If, to expand upon this hypothetical, when the defendant was arrested within the jurisdiction, the defendant is, of course, Mirandized. As soon as we cross over this county line and the defendant decides to spontaneously waive his right to silence and state, I was drinking a lot. In fact, I had 1, 2, 3, too many. That imaginary line can't cut this off under the color of office doctrine, even if he was.
The interesting anomaly on that is, if you accept Mr. Hyman's argument, if the police officer waited until he was out of the city limits and then asked questions of the defendant without Mirandizing him, if he's acting as a private citizen, would that be, a way to avoid suppressing those statements? But my bigger concern here is on Griffiths. Griffiths, you had the crime was, I guess, in Titusville, and an officer sought a search warrant, and the search was going to be conducted in Cocoa. And our court found that, the officer could not do that. He could not execute the warrant in Cocoa, even if it appears the language of the warrant didn't authorize another official from Cocoa to be there. But be that as may, the officer from Titusville was not authorized to execute the search warrant. And the search warrant, of course, can only be executed by a law enforcement officer. So here you have a statute that says the request for the breath test has to be by a law enforcement officer. So how would you distinguish Griffiths from this case?
Well, Your Honor, I would distinguish Griffiths first off because, again, we are dealing with a search warrant in this case. And Griffiths was, it's important to note that within that, that particular statute regarding the searches and seizures is to be strictly construed. Within that case, yes, the crimes occurred within Titusville, and yes, Titusville officers were listed in the search warrant. That simply just wasn't allowed based on 93307, despite that it said any police officer. According to the Fifth's opinion, it didn't address the continuing investigation exception when I went over the text of this. It really just said, you have no power to act outside of the territory of your municipality. I think that because of the fact that we're dealing with a search warrant in a case where, yes, the property was stolen in Titusville, but we know that it's in Cocoa. Instead, this could have been remedied much easier by the search warrant, just stating, have the Cocoa police officers execute this warrant, or Of course, the Cocoa police officer could have executed the warrant instead. Instead, it
Well,
was
in this case, could the situation be remedied if there's a deputy in Orange County who made the request for the breath test?
well, I believe in that case, Your Honor, it would be remedied under the mutual agreement exception, and we would not be
But even if
addressing.
there wasn't a mutual agreement, if an Orange County deputy had made the request, would that have defeated Mr. Hyman's argument?
I mean, if it was an Orange County deputy who was
Present.
who was present at the scene, I believe this.
No, not present at the scene, but present at the place where they did the DUI breath test.
I certainly think that that would defeat the argument of the defense as well. Of course, that's not what we have here, and what was done here is sufficient enough. But I do not. I do agree that had we had an Orange County deputy, because Winter Park, at least as testified on the record here, was within the Orange County jurisdiction, that would have been fine. To address just my two other points on rebuttal, just the trial court wasn't bound by Matos in this case. Yes, it's one of the most recent decisions, and yes, it concerns breath test results, unlike a lot of the other cases. But the trial court was presented with other authority from the state. While admittedly, the Dobson case, that's only a county court order, no precedential value upon the court. It cited numerous DCA decisions referring to the continuing an investigation outside the jurisdiction exception, whether through State versus Cahill, one of the earliest ones, Parker versus State, another of them, Chapman. The trial court had other authority to rely on besides Matos. Just because Matos is the most specific or the most recent authority and specifically addresses breath test results, that doesn't make it weightier in precedential value. The trial court was allowed to pick and choose from both of these because, again, Griffiths does not foreclose the continuing jurisdiction exception here. And just
let me ask you this, if I could. In the Knight versus State case, the officer who was arguably following up on an investigation begun within the jurisdiction, even though the crime venue is kind of amorphous because it was an internet pornography issue. That officer was not relying on what she could just gather with her own senses. Wasn't she using technology that was more likely permitted because she was law enforcement?
I mean, certainly accessing these folders, if you weren't law enforcement, of course, would have been a violation of law on its own. So that's correct, Your Honor. The officer was using, in theory, color of office in Knight in order to access those files on the shared network. But that being said, in this case, there was good faith that these files in that particular case, the folder can be accessed within the jurisdiction, because the way that shared folders operate, whether we're going back in the day to the Napster world, any computer can access this. So at the time, the fact that these files uploaded by the defendant in Knight were on the computer, this investigation is beginning in whichever county where you're accessing these files. Of course, I believe Knight also had a mutual aid agreement, and that was in evidence. So, of course, it doesn't specifically address the continuing jurisdiction, but I believe that it would have been sufficient to use that in this case. And as just my final third point of rebuttal with the out-of-state cases, this isn't an abuse of police power transporting them. As said, Matos, Sills, all of these cases are distinguishable because this investigation began within the Winter Park jurisdiction. In fact, Sills, it should be said that the quoting of Phoenix at the end of that opinion, if anything, should be construed as dicta, because it first holds that the case law regarding the subject matter beginning within law enforcement's jurisdiction that was distinguishable from the facts of this case. They were quick to reject the state's contention that the investigation only has to start within the jurisdiction. There, they distinguished that from the subject matter of the jurisdiction. In that case, the subject matter of the investigation wasn't pulling over Sills or Silas for his traffic offenses. It was the oxycodone that was in another jurisdiction. That was the subject matter. Here, our subject matter was that this person was driving DUI. While, of course, this case could go forward based on just the theory of her facilities appearing impaired, they're allowed to charge in the alternative that her breath test results yielded a blood alcohol level that was higher than the legal limit. And that's a continuation of the same investigation as used here. And just to, again, say, while, of course, a case like Sabrino has very heavy language saying, you know, the most strict remedy should be applied, being the exclusionary rule, that was a case where it was an officer from another jurisdiction pulling someone over in a different jurisdiction. So it's just completely distinguishable from our facts. And as the state cited in the Wingate case, this just does not amount to a violation that should warrant the exclusionary rule. If there are no other questions from your honors, the state will rely on its briefs, and I ask that you reverse the trial court's order.
All right. We'll go ahead and be in recess. Thank you both for your arguments.
Thank you.